Swayam Prabha. Digital India. Educated India.
Welcome to the session on land laws. In today's session, I will talk about the emerging issues in land rights. But before I will start this session, in my previous lecture, I had discussed and talked about the land disputes and legal remedies, in which I had given an overview of the certain laws which deals with the land rights and how the land dispute arises, like when there is a disagreement between the parties over the title or right of a property regarding a certain piece of immovable property or any building, regarding ownership, possession, partition, maintenance, it may be of any kind. So, whenever this dispute arises, the parties may go before the court for obtaining remedy, and other alternative dispute redressal is also there. In that lecture, I had given an overview of certain laws which governs land rights, like we have Indian Contract Act 1872, in which the essential elements of a valid contract is given, like there must be two parties, they must enter into a valid contract, the parties must be competent to contract, there must be a consideration to support that, there must be lawful consideration and object, it must not be fraudulent or immoral. And the thing is, if one party makes a breach of contract, then the other party has the remedy to obtain damages from the court to get compensation. So, sometimes what happen, the party they do not want damages, but they want specific performance of the contract. So, court may pass an order regarding performing the specific performance of contract. So, we have this Indian Contract Act for governing land rights. Then we have Transfer of Property Act 1882, which basically deals with the transfer of immovable property between two living persons. So, it excludes transfer by operation of law, by court's order, and the other like inheritance or will, because here this act it talks about the transfer between two living persons. It means both the person must be in existence at the date of transfer. It must be conveyance must be there, because it is not automatically transferred, like in the case of will or inheritance there must be some activity, and it is the Transfers Act basically by which there is a transfer of immovable property. And in this we had discussed certain transactions amounting to transfer of property, like we have sale, lease, mortgage, exchange and gift, and we have certain transactions not amounting to transfer of property, which is partition, compromise decree, relinquishment decree, family settlement. So, these are the transactions not amounting to transfer of property. So, this act it basically governs the transfer of immovable property between two living persons, to deal with the about the rights given here, because it talks about the present property, not of any future property. Then we have Indian Registration Act 1908. I had given an overview of this act also in my previous lecture, because registration is compulsory for certain types of transactions like sale, mortgage, lease, but there is a provision which is section 18 deals with the optional registration, because there it is not mandatory like in the case of will. In will there is not a requirement of mandatory registration, it may be made without registration. So, this Indian Registration Act it basically there to prevent frauds, basically ensure transparency and maintain the land records, accurate land records. Then we have Indian Stamp Act 1899, which basically purpose here is to generate revenue for the government. So, I had given an overview of all these acts which deal with the land rights. We have remedies also, whenever there is a dispute, there will be a remedy which is given by the court. We can use certain other alternative resources such as mediation, negotiation, arbitration, conciliation for obtaining relief. So, in this the foremost is mediation, because in mediation the mediator, he assists the parties in resolving the dispute, and it is only the parties' decision here. Parties, because it is not imposed by the mediator like a judge in the case of litigation, because that is based on the general principles of evidence. The decision is binary in nature, one party win, the other party lose, but here through mediation and negotiation both the party has won, because there is a win-win situation. So, it is more beneficial than the litigation. We have arbitration and conciliation also, but in that there is a requirement of arbitration agreement. Prior to the going before the arbitrator, there must be an agreement between the parties. So, in that lecture I had discussed all about this alternative redressal forums, the mechanisms of the ADR, and about the land disputes. So, in today's session I will first start with the emerging issues in land rights, and in this I am going to talk about the history of land rights in India, the objectives of the land reforms, role of the land reforms in agricultural development, emerging issues in land rights in India, the relevant laws and policies in India, and then the conclusion. So, first I will start with the introduction here, because land, we all know, it is a symbol of identity and often the only source of livelihood for marginalized people and communities in developing and underdeveloped countries, because this land is a cornerstone of the nation's legal and socio-economic framework too. Almost 60% of all Indians are directly dependent upon the land for their livelihoods. So, this land rights, it basically impact upon many facets of our day-to-day life. Land is not just an economic resource, it is also central to individual dignity and community identity, history and culture. Access to land is of fundamental importance in rural India, because the incidence of poverty is highly correlated with lack of access to land. The Indian Constitution adopted in 1950, which safeguards the land rights of scheduled tribes, and through the inclusion of the fundamental right to property in Article 19(1)(f), it guaranteed equal property rights to all Indians, including women and Dalits or scheduled caste for the first time. So, access to land is of fundamental importance in rural India. We have in our constitution prior to the 44th amendment the right to property as a fundamental right, which is given in Article 19(1)(f), which guaranteed equal rights to both men and women regarding the land. Now, I will talk about the history of land rights in India. Vedas prohibit land grants, because it at the dawn of civilization, many of our customs, rituals, beliefs, land holding patterns, etc. were born from the basic necessities and realities of day-to-day life. The idea that land could be an object of purchase and sale had not yet been established during the time of Vedas. So, they prohibit the land grants at that time. Land ownership during the tribal period, because in the tribal setup of the days of the Rig Veda, that is before 1500 BC, every male member of a tribe had to work in the collective activity of hunting. So, when the disintegrating tribal society of hunters took up agriculture to be its prime occupation, land was collectively owned to begin with. So, every member of the tribe had an equal right to whatever the tribe produced collectively. So, then we have Manusmriti on the rights to land ownership. According to an ancient text, the Manusmriti, land belonged to him who first cleared the timber and a deer to him who first wounded it. This couplet makes it clear that, at least to begin with, the title to property of land was allied to the labor put into making it cultivable. The pre-British scenario, because traditionally in India before the coming of the British, we have private ownership of the land, which was an unfamiliar idea, and land was generally owned by the village community collectively. So, a proper land revenue system was initiated by Todermal during the reign of Akbar. Under this system, land was measured, classified, and the rent was fixed accordingly then. When the leash of power went into the hands of the British, a sea change was seen in the pattern of ownership of land in India. So, land ownership patterns under the British rule, it go under a sea change basically in the pattern of ownership of land, because Lord Cornwallis introduced the permanent settlement in 1793. Under this system, a class of landlords called zamindars was created, whose responsibility it was to pay a fixed rent to the government for the lands they owned. Rayotwari system, in that system the proprietor of land, they gave the rent and taxes directly to the government in the absence of any middleman. So, this started in Madras and was later adopted in Bombay as well, this Rayotwari system. This system was introduced by the William Bentinck's government, under which landlords were responsible for the payment of revenue to the state. These landlords or the zamindars had a whole village or a group of villages under their control. The Mahalwari system prevailed in UP, the northwestern province, Punjab, and parts of central India. Now, I will talk about the land reforms since independence. Committee under the chairmanship of J.C. Kumrappan was appointed to look into the problem of land. The Kumrappa Committee's report recommended comprehensive agrarian reform measures. The land reforms of the independent India had four components. First one is the abolition of the intermediaries, the tenancy reform is there, fixing ceilings on land holdings, consolidation of land holdings. So, these are the four components in that reform. Then we have land policy in India, which has undergone broadly four phases since independence. The first and the longest phase was there in 1952 to 72, and it was characterized by land reforms that included three major efforts: the abolition of intermediaries, the tenancy reform, and land redistribution through land ceilings. The elimination of intermediaries here was relatively successful, but tenancy reform and land ceilings were not. The second phase starts between the period 1972 to 1985. It basically focused on cultivating previously uncultivated land. The third phase starts between 1985 to 1995. The watershed development, drought prone area development, and the desert area development programs were implemented during this phase. The central government established the Wasteland Development Agency to focus on wasteland and degraded land. The fourth and the most recent phase, which starts from 1995 onwards, it basically focused on disputes regarding the requirement to continue with land law and attempts to enhance land tax administration, particularly clarity in land records. Now, I will talk about the earlier stages of land reforms, which is basically focused on food production, expanding technology, and eliminating regressive institutions. Poverty needed to be addressed. So, these land reform measures were basically divided into four categories by Raj Krishna, an Indian economist. In this, the first category is liberating. The liberating measures here attempted to free the real tillers of the soil from the landlord's oppression. This was accomplished by granting the renter land ownership or occupation rights. So, rent fixing was done in a few states such as West Bengal's Operation Barga, where the tenancy was documented. The second factor, the second category here is distributive. The distributive measures were intended to do this by providing tangible resources to the poor as guaranteed in our Indian Constitution, particularly those who required land as a productive resource. So, this was accomplished by dispersing land ownership from major landholders to the landless people, particularly from socially disadvantaged groups. Then we have organizational, because in the mid of 1960s, organizational changes, it aimed at selecting and executing a specific type of agricultural production practice which were implemented with the support of technical environment. Then we have developmental reforms too, which addressed additional concerns related to land policy, which influenced the entire agricultural industry's growth. Now, I will talk about the importance of land rights in India. Land rights in India hold significant importance due to several reasons. The importance of land rights in India is underscored by its role in addressing key legal issues, which are, first one is agricultural economy. India's economy is predominantly agrarian, with a substantial portion of the population engaged in agriculture. Land rights are crucial here for farmers' livelihoods, providing them with security of tenure and enabling them to invest in land, improve agricultural practices and access credit facilities. By protecting or by clarifying ownership rights and secure the tenure regarding the land rights of the landowners, to prevent from the encroachment and ensure and give protection to the landowners and ensure lawful possession. We have this aim in the by providing the rights to the landholders, the stakeholders, the people who are weaker in the society. Then we have social justice, the another reason. Land rights play a vital role in ensuring social justice and equity, particularly for marginalized communities such as Dalits, Adivasis and landless farmers. So, secure land tenure empowers these communities by providing them with a means of economic upliftment and reducing vulnerability to exploitation and displacement. So, we have this reason also, that is socio-economic significance, like because land is a vital resource that underpins the economic development, agricultural productivity and housing. So, this basically the knowledge of law is here essential to understand how the land can be effectively utilized and protected, and how the the mechanisms, to know about the mechanisms for the dispute resolution. Then we have the another factor, that is urbanization and industrialization. So, with rapid urbanization and industrialization, there is increasing pressure on land resources. Secure land rights are essential for protecting the interest of both rural and urban populations, preventing forced evictions and ensuring fair compensation in case of land acquisition for infrastructure or industrial projects. So, this is another reason, urbanization and industrialization, because with rapid urbanization the demand of land has been increased and it leading to complex legal this land related disputes and challenges. So, there must be securing land rights here are essential for protecting the interest of both the rural and the urban populations, and they are critical basically to balance the development, urban development and infrastructural projects, and ensuring fair compensation in case of land acquisition for infrastructure projects too. Next, we have environmental conservation. Land rights are closely linked to environmental conservation efforts. Secure land tenure encourages sustainable land management practices and reduce land degradation, deforestation and encroachment on ecologically sensitive areas. So, this land law, it intersects with environment development, environmental regulation and social justice concerns, and it basically it helps in not to because these urban projects, these urban development and these infrastructure projects, we have to ensure that they do not encroach the and the minimize the ecological balance, and the protecting from that degradation and deforestation and the encroachment on ecologically sensitive areas. Then we have another factor, that is empowerment of women, because in many parts of India women have limited access to land and control over land resources due to patriarchal norms and discriminatory inheritance practices. So, ensuring equal land rights for women is crucial for gender equality, women's empowerment and poverty. So, it also provides and give women to access the land with to control over land resources due to the patriarchal norms. It is earlier the limited rights had been given to the women, but now after the amendment in the Hindu Succession Act also, that gives women equal rights as the male in ancestral property. So, by ensuring equal land rights for women here is crucial for gender equality in matters of succession, women's empowerment and poverty too. Now, I will talk about the objectives of land rights and the land reforms. So, here the main objective of land reforms can be summarized here as increase agricultural productivity through investment by the landholders in agricultural extension, agro processing, marketing and value added services. So, this will also contribute to stabilizing food prices and increasing household income. So, this is the main and the foremost objective of the land reform, by increasing agricultural productivity through the investment by the landholders, the stakeholders in the agricultural extension, agro processing, the marketing. So, this can only be done by the contributing to stabilizing the food prices and the increasing household income. Another objective is to reduce poverty and increase the incomes of landless poor and marginal farmers by giving them improved access to credit and market facilities. So, reducing poverty is the another objective, by increasing the income of the landless people by providing them land and by providing giving them the improved access to the credit, so that they can improve their life. Next objective is provide a sustainable, efficient and equitable mechanism for land distribution. Then next objective is to improve overall management of natural resources, including forests, water, fisheries, etc., by involving all stakeholders in planning for sustainable development. So, these are the main objectives here of the land reforms. Next, I will talk about the role of land reforms in agricultural development. Land reform eventually leads to an increase in the agricultural production through land development and distribution. The small farmers greatly benefited by receiving the inputs provided by the government that earlier was beyond their reach. So, the land reform, it basically increases the agricultural productivity through the land development and distribution, and it benefited by receiving the inputs which are provided by the government. The small farmers, they greatly benefited by this reform. Next is increased agricultural growth and productivity, enhanced farmers' financial condition by generating a scope more income, which helped in reducing the poverty level in the rural community. So, by increasing the agricultural growth and productivity, it enhanced the farmers' financial condition too, by giving them by generating a scope for them to gain more income, which helped in reducing their poverty level in the community. The less involvement of intermediaries here allows the actual landholders to strengthen their positions and authority over the entire agricultural activities. So, this helps them to enhance their social and economic status and contribute to the development of the agriculture sector. The process of land reforms, it involves strategic measures to restructure the methods of land use for the overall development of the agriculture sector, and there have been major reforms observed in the system of rural credit to promote farming, assist in marketing and educate people for reaping the benefits of the reforms. As a part of land reforms, the maximum and minimum area of the land holding has been specified to ensure equality in the distribution of land. The cooperative farming scheme, as suggested by the government, it allows the landowners in the rural region to form a cooperative structure to access the lands for cultivation purposes. This system has encouraged small landholders to maintain their bargaining power in the competitive pricing and marketing structure. So, as part of land reform, the maximum and minimum area of land holding which has been specified to ensure equality in the distribution of land. We have the process of land reforms which involves strategic measures. We have the less involvement of the intermediaries which allow the actual landholders to strengthen their position. This land reform, it leads to an increase in agricultural production through land development and distribution. Next, I will talk about the emerging issues in land rights in India. Land for the absolutely landless, this is one of the emerging issues in the land rights. India has by far the largest number of rural landless people on the planet, and rural landlessness is closely associated with poverty. So, efforts to reduce poverty, it must include efforts to provide land to the landless. So, this is also one of the main objective of the right to fair compensation, transparency and acquisition of land acquisition, rehabilitation and resettlement act. Its main objective here is to provide land to the landless and to acquire land for public purposes, to provide compensation to the affected parties. So, this is one of the major issues. Second is regularizing informal occupation. Tens of millions of poor rural and urban households are long time occupants and users of government owned land, but do not have a formal legal rights to the land. This includes land used for residential purposes, land used for agricultural cultivation, for non-timber forest products and land used for other community purposes. Improving land records. Although the situation certainly varies by state to state, the general inadequate state of land records in India, these inadequate land records are a significant source of land tenure security, certainly for the poor, but also much more broadly. Inadequate land records also facilitate corruption, contribute to the high and costly incidence of land disputes. It reduces the government's ability to conduct effective planning and raise revenue, and generally limit the capacity for good land governance. As we have with the Indian Registration Act, which basically aims to prevent records, to maintain the adequate land records, but in spite of that we are facing nowadays various shortcomings in this one, like reducing the government's ability to conduct effective planning and raise revenue, which is here by giving land tenure security, because the computerization is talking about here regarding the digital land records, because now it is the time of the digital, we have a technology. So, in this the recording of land rights and their periodic updating is a prerequisite for an effective land policy basically, because this not only eliminates the harassment of the farmers, but also indirectly contributes towards the efficiency too. So, during the seventh plan in the 1987 to 88, certainly a central sponsored scheme on computerization of land records was introduced as a pilot project in the district of Karnataka, Andhra Pradesh, Assam, Bihar, Gujarat, Madhya Pradesh, Odisha and Rajasthan, because its main objectives were computerization of ownership and plot wise details for the issue of timely and accurate copy of the records of rights. So, to achieve low cost, easily reproducible storage media for reliable, durable preservation, to provide fast and efficient retrieval of information, both graphical and textual, creation of a land information system. So, the scheme is making slow progress. So, some of the constitutional, the operational problems here are delayed transfer of funds to the implementing authority, delay in development of need based software, poor computer training facilities. So, the Planning Commission had appointed a one-man committee on record of rights in the 1980s, and it emerged out of this work and no policy initiatives were followed thereon. So, that is why there is a requirement of improving the land records, certainly because the inadequacy in providing the accurate land records, it is basically facilitate the corruption. So, it contributes to the high and the costly incidence of land disputes, because many land disputes arises because of this one, because there will be a fraud if there is no accuracy in the land records, if it is not registered. So, it reduces the government's ability to conduct effective planning and raise revenue. Next, we have farmland rental or leasing. Farmland rental markets are a powerful tool for both increasing land access to landless and land poor households and for more efficient use of land. Unfortunately, the highly restrictive farmland rental restrictions in most Indian states have had a demonstrably negative impact on the poor's access to land, on the tenure security of most tenants because of their informal status, and on overall agricultural efficiency. So, these farmland rental markets are a powerful tool for both increasing land access to the landlords and the land poor households, and for the more efficiency of the use of land. In this, we have the land administration to one of the major concern here, because the development of land resources in the Union Ministry of Rural Development, they addresses the issues pertaining to land administration, particularly degraded lands, and has a range of programs that set the national framework. So, these programs are passed on to the state governments as guidelines, but more frequently at the final design. So, at the state level, there are the land development boards too. Next, we have simplifying and harmonizing the land legislation. Many provisions are outdated, irrelevant, overly complicated and inconsistent. So, this is also again one of the major issue regarding the land rights, because the provisions are outdated, they need amendment in the provisions, they are irrelevant, they are not relevant for the process, and they are too complicated, their inconsistency is there. Increasing land related legal awareness and services, because limited access to legal services for the poor, the NGOs, law colleges and universities and legal service agencies could do much to fill in the gap. So, earlier we have a limited access to the legal services, but now we have the provisions, there is a need to increase land related legal awareness. The parties must be aware about their rights, about their land rights. The land law here addresses those challenges related to the property rights, related to the land rights. So, the poor persons must be aware that they have a free legal aid too in our constitution, and the legal service agencies must provide them to fill this gap. Next issue here is closing land data gaps. So, face land related data gaps, who has a land rights and the nature of those land rights, the government are not routinely collecting this data in India. So, closing land data gap is again one of the major concern. It is one of the emerging issue here, because the facing land related data gaps, who has the land rights and the nature of those land rights, who has the right to access the land, who has not. So, this is not there in the data. There is a need of land survey too, and the government are not routinely collecting this data in India. Next is strengthening women's land rights, because it limits India's economic and social progress. Level of women's land ownership in India are particularly low, and level of women's land tenure insecurity are high. So, most women are dependent on men in their lives to access and use land. So, there is a need of strengthening the women land rights. They must given equality in the with respect to the land use, with respect to the control over the land. They should be given equal access to the land as compared to men, because earlier what happened, most women were dependent on men for their livelihood and for using the land. So, it limits India's economic and social progress. Now, I will talk about the few relevant laws and policies in India relating to the land use. We have the right to fair compensation and transparency in land acquisition and Rehabilitation and Resettlement Act 2013 here, which basically the main aim of this act here is to ensure the transparency, to give compensation, fair compensation to the affected party, and the reason for the land acquisition for government purposes and rehabilitation and resettlement should be given to the parties. Then we have right to fair compensation and transparency in land acquisition, rehabilitation and resettlement, Gujarat Amendment Act 2016. We have the Rajasthan Land Pooling Scheme Bill 2016. We have an agreement with the Ministry of Rural Development and Jan Satyagraha on land reform in India 2012. Parliamentary Standing Committee report on the land acquisition and rehabilitation and resettlement bill 2011. National Rehabilitation and Resettlement Policy 2007, the Scheduled Tribes and the other traditional forest dwellers, Recognition of Forest Rights Act 2006. So, these are the relevant laws here with respect to the land rights and the land use. In the last, I would like to conclude that the government needs to work on land rights, because the main reason here is agricultural productivity boost. Land reform initiatives have yielded promising outcomes by enhancing agricultural productivity, facilitating more efficient cultivation practices and minimizing labor and cost associated with fragmented land ownership across diverse locations. Social and economic advancement, the another one is, these reforms have not only improved agricultural productivity, but also fostered social and economic progress within farming communities, empowering landholders to actively participate in agricultural and economic development endeavors. We have structural shift in land ownership, because by altering the social and political dynamics surrounding land ownership, these reforms here have reshaped the power structure, granting genuine landholders greater agency in agricultural and economic affairs. We have empowerment of landholders, because the empowerment of legitimate landholders has translated into more effective contributions to agricultural development and the broader economy, driving positive growth trajectories. Integral to agricultural and economic development, in this land reform emerges as a pivotal driver of agricultural advancement and economic prosperity, underlining its critical importance in fostering sustainable development and equitable progress. So, in this basically, as I had discussed about the emerging issues in land rights. So, in this basically the importance of land rights, the importance of land laws in India is basically underscored by its role in addressing these key legal issues, like we have this one the first one is land ownership and tenure, because by clarifying the land the ownership rights and the security of tenure to prevent the encroachment and to ensure lawful possession, we have this reason. The another reason is by navigating the process, the legal process of acquiring the land for and by protecting the interest of both the state as well as the interest of the individual, and by streamlining the registration process to prevent fraud, by ensuring transparency there and to maintain accurate land records too. And the next is the importance of land right here. The next point which is important to note is by intersecting it with the environment regulation and the social justice concern here, and basically it works with the various land related regulations, like we have environmental law, we have this zonal laws, we have this urban development estate development statute, urban planning statute. So, it mainly works with those laws too, and we have these issues arises because the main because land is a vital resource here. It is important because it underpins the economic development, the agricultural productivity here and the housing, and it is important to note here that due to the rapid urbanization, the demand of land has increased nowadays, and due to which the complexity is there regarding the land related issues, the legal challenges that were faced here. So, the party must know about their rights, about the protection of the property, how the land can be effectively utilized and protected, the mechanisms for resolving their disputes. So, these are equally important here in understanding these points, because by only this we can more implement because we have certain laws we know, but we have certain drawbacks also, we have certain shortcomings in there. So, we need a land reform in this perspective. I will talk about the role of land reforms in agricultural development. So, first of all we need to know what is land reform basically. So, this land reform here it usually refers to the redistribution of land from the rich to the poor. More broadly, it includes the regulation of ownership, operation, leasing, sales and inheritance of land. The land is precious here for any country and used by people for productivity and as a source of food, for a place to live, for wood, for a place to work. So, land is precious for everyone. Not surprisingly, it received top priority here on the policy agenda at the time of independence. In the decades following the independence, India passed a significant body of land reform legislation. At the time of independence, we have the ownership of land which was introduced and which was basically concentrated in the hands of a few people. So, this led to the exploitation of the farmers, and it was a major barrier towards the socio-economic development of the rural population. So, equal distribution of the land was therefore an area of focus of the independent India's government. Laws for the land ceiling were enacted in various states during the 50s and 60s, which were modified on the directives of the central government in 1972. So, in this way basically deals with the economic and political arguments in favor of land reforms, and review the Indian evidence here on the effect of land reform on agricultural productivity and the poverty. because after independence the Agrarian Reform Committee under the chairmanship of J.C. Kumarappa, this was appointed by Indian National Congress. The committee here recommended that all the intermediaries between the state and the tiller should be eliminated. Some of the steps taken, which is based on the recommendation of the committee here, is intermediaries abolition, surplus land distribution among the landless or semi-landless peasants, fixation of ceilings on land holdings. So, land reform and land distribution here is basically important, because in India there was a practice of land holdings from historic times, and it was distributed in highly unequal manner and has always been used as a source of social power to get secure access to land for the poor and the landless. Policies of land reform were implemented to benefit poorer sections of the society since independence. So, after that a number of land reforms have been done by the government, such as the abolition of zamindari or middlemen as revenue collectors, imposing a ceiling on land holdings and awarding of the surplus land rights to landless, and the tenancy reforms. So, the purpose of land reform here is the efficient use of the scarce land resources, redistributing the agricultural land in favor of the less privileged class in general and cultivating the class in particular. Under the 1949 Indian Constitution, states were granted the powers to enact and implement these land reforms, and this autonomy here ensures that there has been significant variation across states and time in terms of number and types of land reforms that have been enacted. So, we classify land reform acts into 4 main categories according to their main purpose. The first category is the act related to tenancy. These include attempts here to regulate the tenancy contracts both via registration and stipulation of contractual terms, such as shares in share tenancy contracts, as well as attempt to abolish tenancy and transfer ownership to the tenants. So, this attempt here regulate the tenancy contracts, in which the basically Indian Contract Act and the Transfer of Property Act 1882 plays an important role via registration. So, in that case the importance of Indian Registration Act is also there, because under Indian Contract Act the parties have certain terms and conditions with respect to the possession of the land, with respect to the sale deed which was executed under the Transfer of Property Act. So, this is the first category here, which is related to the tenancy reform. Second category of land reform here attempts to abolish intermediaries, because these intermediaries who worked under feudal lords, the zamindari, to collect rent for the British were reputed to allow a larger share of the surplus from the land to be extracted from the tenants. So, most states had passed legislation to abolish these intermediaries prior to 1958. The third category of land reform, it concerns efforts to implement challenges on land holdings with a view to redistributing surplus land to the landless people. So, finally, we have acts which attempted to allow the consolidation of disparate land holdings, though these reforms and in particular the latter were justified partly in terms of achieving efficiency gains in agriculture. It is clear from the acts themselves and from the political manifestos supporting the acts that the main impetus driving the first 3 reforms was poverty reduction. So, despite the considerable publicity attached to their enactment, political failure to implement was most complete in the case of land ceiling legislation. So, as a result of these problems, the implementation of both tenancy reform and land ceiling legislation, it tended to lag well behind the targets set in the 5-year plan. So, there is a considerable variation in overall land reform activity across states, with states such as Uttar Pradesh, Kerala and Tamil Nadu having a lot of activity, while Punjab and Rajasthan have very little. So, there is a variation in tenancy too, because if I am talking about here cash tenants, because they pay a fixed tax for the use and occupation of the land, they pay part of their rent in cash and the other part as a share of the crop. They pay a share of crops only. So, the main objectives of the land reform here are to make redistribution of land to make a socialistic pattern of society. Such an effort will reduce the inequalities in ownership of land, to ensure the land ceiling and take away the surplus land to be distributed among the small and the marginal farmers, to legitimize tenancy with the ceiling limit, to register all the tenancy with the village panchayats, to establish a relation between the tenancy and the ceiling, to remove rural poverty, proliferating socialist development to lessen social inequality, empowerment of women in the traditionally male driven society, to increase the productivity of culture. So, to see that everyone can have a right on a piece of land. So, protection of tribals by not allowing outsiders to take their land. So, these are the major objective of these land reforms. So, the most obvious argument in favor of the land reform is equity here, because in a land scarce country with a significant section of the rural population below the poverty line, the case for ensuring that everyone has access to some minimum amount of land, it seems compelling from this point of view. So, here the small farms tend to be more productive than the large farms. Another empirical regularity here is that owner cultivated plots of land tend to be more productive than those under sharecropping tenancy. So, one could make the land reform based not only on equity considerations, but also on efficiency. For example, the inverse relationship between farm size and the productivity, it suggests that land reform could raise productivity by breaking large farms into several small farms. Also, lower productivity under sharecropping suggests that land reform could raise productivity by converting the sharecroppers into owner cultivators. We have the land ceiling, because the land is a source of income here in rural India land, and it provides employment and opportunities to the landless people. So, therefore, it is important for the marginal farmers, the agricultural laborers and the small farmers. The concept ceiling on land holdings, it denotes the legally stipulated maximum size beyond which no individual farmer can hold any land. The objective of such a ceiling here is to promote economic growth with social justice. So, land possession and the social power is important here. So, these are the important objectives of the role of land reforms in the agricultural development. The importance of land rights here is underscored by its role in addressing these issues basically, because land is a vital resource in the because it comprehending the legal, social and economic dynamic that governs one of the country's most valuable resources here. So, it is necessary to know about their rights, how to resolve the disputes regarding the land or regarding these land reforms, because it leads to an increase in agricultural productivity. So, if no land is given to the landless and the more and more lands are given to the person who has already lands, so in that case it will imbalance the and it will hugely affect the society, and the small farmers, they greatly influenced by receiving the inputs here which is provided by the government. So, in this the land reforms I am talking about here, The less involvement of intermediaries allows the actual landholders to strengthen their position and authority over the entire agricultural activities. So, these play here an important role in this. So, the cooperative farming scheme here, as suggested by the government, allows the landowners in the rural region to form a cooperative structure. So, that is why the land law here, it deals with the various land related regulations, it ensuring the compliance with those regulations, like we have zoning regulations, we have environmental law, we have urban planning statute. So, there must be the compliance with these regulations too here, to give the land rights to the landless people here. So, basically this is the main aim and the objective of the land reform, which tends to increase here in agricultural productivity by providing land and redistributing land to the landless persons. Thank you.
Hello, I am A.K. Sharma and I teach sociology in IIT Kanpur. I am trying to answer a simple question: how sociologists explain their facts. As you know that sociology was developed as a subject dealing with human behavior, but which would use the tools and techniques of science, mathematics, physics, chemistry. But this view that human behavior needs to be studied scientifically has been contradicted later on, and it was said that simply by relating one kind of facts with other kinds of facts, you cannot understand human behavior. To understand human behavior or to actually theorize about human behavior, you have to theorize the theories or motivations or meanings that people have in their mind in involving in a particular action. Now, using these two traditions, one tradition in which we relate one fact of society with other facts scientifically, and another tradition in which we try to develop second order constructs or theories that people have in their mind in acting in day to day life. They have produced two different traditions in sociology. One is called quantitative, another is called qualitative. Quantitative methodology uses scientific methods of conducting surveys, censuses, experiments, and then by using statistical methods, from simple method like arithmetic mean to sophisticated methods like logistic regression, we try to arrive at some inference. Qualitative tradition, qualitative methodology on the other hand uses ethnographic approach, and here the researcher attempts to become part of the community which he or she intends to study, because the assumption is that only by becoming part of the community, by living among the people whom you are studying, and by putting yourself in their shoes, by trying to understand things or their environment or their behavior or their culture or festivals or economic behavior or politics from their angle, from their perspective, how they feel, what understanding they carry in their mind, that only by understanding these things we can understand facts of society. Actually, in one of the latest works, World Bank, which uses a lot of statistics, has also talked about understanding mental models that people use in involving in behavior.